Hello, everyone. My name is Andrew Nyamayaro. I'm a solicitor at Tanlo Solicitors, and I'm just going to make the weekly presentation on legal updates as much as I can for this week. I'll start with the presentation on immigration. And on immigration, the first thing that I'd want to bring to your attention is that from the 15th of June up to the 21st of June, it's the refugee week. So we need to attend any event that is happening within your local vicinity pertaining to any refugees or people applying for refugee status in any particular country, in whichever part of the world they are. So Refugee Week, next week, some activities are happening. I'll be attending some activities with refugees or organizations representing refugees, and hopefully we should be able to get something from there. Again, I just want to remind people that Brexit, the transitional period will be ending on the 30th of June. If you are an EA national or an EEA national or EEA family dependent, you need to make your application as soon as possible. The deadline for most applications is the 30th of June, 2021. Some applications might go beyond that deadline, or for example, if it is a Surinder Singh application or other applications, they might go beyond that deadline. But just for you to be sure, and for you to beat the deadline, it's best for you to make your application before the end of this month, because that is the major deadline in terms of the Brexit and submitting your application under the European Union Settlement Scheme, commonly known as EUSS. So that is a major announcement that I need to make to you, and that you should consider making your application as soon as possible. Okay, so having said that, I'm also happy to announce to you that there has been a recent case which will assist many people who have got British national children, but they themselves do not have leave to remain in the UK, or their leave to remain is based on the children. Recently, a case has been decided for a claimant called Akin Sanya. It was a judicial review case, and it involved a Nigerian lady who came to the UK and was granted a derivative family permit for 5 years. And before it had expired, she had some financial problems, and she switched her visa from a Zombrano or a derivative family permit to a limited leave to remain under the immigration rules. And when she heard of the European Union Settlement Scheme, the EUSS, she decided to switch back. And because the Secretary of State had moved the laws for immigration for EU nationals from the EA regulations to an appendix in the immigration rules, which sidelined or made it not possible for people who have got a possibility of getting leave to remain using other means or other routes, she could not get the visa or the leave to remain. She challenged that decision, and she was successful in the High Court. So I've had inquiries from people in the past. They might be parents, a single parent, or even father and mother of a child who is a British citizen, and they've tried to make Zambrano applications which were refused. So if you made a Zambrano application that was refused by the Home Office, let's say in the past 1 year or so, please get in touch with us. We should be able to assist you. I'm not so sure whether the Home Office is going to try to contact people who have been refused by themselves, or they are going to wait for you to contact them. But if you contact us, we should be able to communicate with the Home Office on your behalf. So if you made an application under Zombrano and it was refused by the Home Office, and they were saying that you have got an alternative means of getting a leave to remain, then that has been declared unlawful by the High Court. So that is the Zambrano route. If you've got a derivative family permit, or if you had applied for it, you're a mother of a British child, then you should be able to apply or to have the Home Office reconsider the decision if they refused you. While it's on this topic of children, you still have other routes that are available. For example, if your child has spent 7 years in the United Kingdom, or if there is a British citizen, and you can apply under the immigration rules as usual, and you get your discretionary leave to remain 2.5 years for 10 years. You should be, sometimes you get recourse to public funds depending on your circumstances. Another topic that has been in the news is about the Napier Barracks. The Napier Barracks is a place where the Secretary of State was housing, or is housing, asylum seekers who have crossed into the UK, mainly from Europe, and they are from all over the world. They come to Europe and then they cross the sea into the United Kingdom, and then some of them are housed at Napier Barracks. The court as well has declared that it was unlawful. It is unlawful for them to be housed at Napier Barracks, which the court has considered that the conditions there are inhumane and degrading. So if you were one of the people or who were housed at that particular facility, you might be able to gain some compensation. You need to consult your lawyer or a legal practitioner. You might be entitled to some compensation. It will then remain a question whether you will get the compensation, and if so, what will be the quantum. If you have any questions relating to the topics that I'm discussing, just put them in the chat, and I should be able to respond to the questions as much as I can under the circumstances. So just to catch up on what I've said so far, Brexit, the 30th of June, you need to make your application before the 30th of June, or check with your lawyer or the TAN law solicitors whether or not your deadline will be the 30th of June, or if your deadline extends beyond that, if you can't make the application as soon as possible. But for most pre-settlement and settled status, it's the 30th of June. And if you've got a child who's a British citizen, and if you were refused a Zombrano application, a derivative family permit, then the court has said that that decision by the Secretary of State was unlawful. So I think you can approach the Secretary of State or your solicitor so that that decision can be reconsidered, and you can submit a new application, or they can make a decision based on whatever information and evidence that you had submitted before. The question that I have in the chat here, which is on the Facebook chat, is that if a person stops to report and they want to apply under the 20 years, can they do that? If you stopped to report and you have now accrued 20 years in the United Kingdom without having spent part of it in prison, then you can make an application under the 20-year route. It's quite possible. You just have to try to gather much evidence as much as possible, considering evidence such as the bills, bank statements, payslips, academic certificates, HMRCE documents, insurances, and so forth. Whatever you have that can prove your presence in the United Kingdom, you can submit it as your evidence to prove your presence in the United Kingdom. So yeah, 20 years you can. It doesn't really matter that you were not reporting. Of course, you would have been in breach of immigration you would have been in breach of immigration rules, but I think you can still be successful. The other question that I am getting is that if you came to the United Kingdom, or if you brought your spouse to the United Kingdom and the relationship has broken down, what are the implications, particularly if there's any children? So if someone came to the United Kingdom on a spouse visa and their relationship has broken down, it will depend on the reasons of why the relationship has broken down. If it's something to do with domestic violence, then the person who came to the United Kingdom can as a spouse can make an application for domestic violence settlement, DV, and if they can't afford the fees, they can apply for a DV concession under legal aid, or if they've got the resources, they can just apply straight away for settlement based on domestic violence. If there is not domestic violence involved, it is just a mutual breakup, no issues, and there's a child involved, and the child has spent 7 years in the UK, or the child is a British child, then the other party may make an application either through access or contact to the child to remain in the United Kingdom, or if they are staying with the child, then they can make an application as the sole carer of that particular child. The status that is given to someone who has been in the United Kingdom for 20 years is 2.5 years. So once your application for 20 years is successful, you will initially be given 2.5 years. You have to renew it 3 times until you accrue 10 years. Sometimes the Home Office, because of the delays they'll be doing in making the decision, the fourth application might run over the 10 years. But as long as your 10 years have been accrued, you can then make an application for indefinite leave to remain. So if you are on the 20-year route, it means that it will take you 30 years for you to get indefinite leave to remain in the United Kingdom. You are not given indefinite leave to remain straight away. You are given 10 years limited leave to remain, depending on your circumstances, with access to public funds or without access to public funds. Okay. I wanted also to touch on employment law, just in very basic terms, because when you are an employee, issues sometimes do happen at work, and sometimes you do have a grievance against the company, or the company might have some disciplinary proceedings against you, for example, for misconduct or whatever thing that they think you have breached in terms of the employment contract. It is important for you to know what the structure of the company is when it comes to discipline and grievance. Most companies do have some office manuals, policies, operation procedures, an employee handbook, grievance procedure, and so forth. And most of them, some companies, they do printed copies, or they put them on their intranet and so forth. So if you are to attend such a meeting, it is important for you to attend with a union member if you are a member of a union. And if you're not a member of a union, you can attend. Some companies allow you to attend with a friend or someone else to help you. And it is important that those persons can give you the moral support and also maybe taking notes on your behalf. Some people have tried to record secretly the proceedings. It's not something that is encouraged, because sometimes it is very difficult to then produce the evidence that was covertly recorded without the knowledge of the other party. So when you take your notes, that should be fine. You should familiarize yourself with the proceedings, who is supposed to be, for example, the chairperson, the note taker. Is the procedures being followed by the company, or is it a proper proceeding, or it's just a sham proceeding that is just done to cover up for the company? Most companies do have their own internal proceedings, or for appeal. It can be appealed once or twice within the company, and then if there's no resolution that has been found and you want to progress the matter further, you can then approach ACAS, ECAS is a mediator. They will try to mediate between you and the company, and if a resolution is found, then that's fine. If a resolution cannot be found, you then have to go to the employment tribunal. It is very important under employment law to know that the limitation of time is very important. Time is the limits. In most cases, it will be 3 months less 1 day from the date when the employment contract has ended. But in some instances, it can be from the date of the Complaint Act or the last act. For example, if it's in discrimination cases, you don't have to wait until you are dismissed or you have resigned. You have to take action within 3 months of the last Complaint Act or the last act of discrimination. So it is important for you to know the deadlines, otherwise your case will be out of time. And the employment tribunal is very reluctant to extend times for cases to go ahead. In the employment tribunal, you don't pay a fee. You complete the ET1 form, and the ACAS would have given you a certificate which you put, that is just a code that you put on the application form, and you then put your particulars of claim either in the form or as an attachment, and then you submit to the employment tribunal, and the respondent will have their chance to then respond through their defense, and the processes will continue like that. There might be a case management hearing, 1 or 2 case management hearings, and then there will be a full hearing. In most cases, the respondent will be asked to prepare the bundle. So it will normally to be a joint bundle between the claimant and the respondent. They will have a single bundle, and at any time, mediation can still go ahead as long as people can try to come and find a settlement. It is sometimes advisable to come to a settlement because the costs and implications of case law and such as Porky can come and affect you when there's been attempts to settle and you have refused it, and it appears unreasonable that you have refused it, or if it appears that you could have been fired anyway. So it's important to take note of any settlement offers that are done if they are reasonable. So if you have any questions on the things that I've presented today, or any other questions that are pertinent to immigration and employment law, I should be able to respond to them. One other question that I've got is, how do I get an employment license to bring healthcare workers such as nurses, etc.? You need to apply for a sponsor license. And for you to apply for a sponsor license, it should be a business that is credible, that is even if that can prove that we have got a need to recruit people from outside the country, and the job should be on the skilled workers list. And most of the people that are making applications at the moment, most businesses that we have dealt with in our firm, is under the health and social care route, which they want to recruit people from outside the United Kingdom, nurses, social workers, auxiliary nurses, senior managers, support workers, and so forth. So the application is done online. We can assist you as a firm to do the application. But in terms of the Home Office requirements, it will be up to the applicant to submit the application. So we do complete the application on your behalf, and then you check the application, and then you click the submit button yourself. You should be able to show that you are registered as a company. For example, you have got registration with the HMRCE, you have got a bank account, you have got a premise where you are working from, there's job descriptions, person specifications, and documents like that. If you require a list of the documents or what we can do for you, you can contact me on the details that are appearing on the screen, and we can discuss it further. But it is possible, and at the moment it is a hot cake. Every company, most of the companies that I know either through our firm or other firms, they are rushing to get this sponsor license, and because they want to recruit from outside the country. The status of being a refugee is not necessarily affected by Brexit. The status of a refugee is regulated by international conventions, not the conventions of the United Kingdom only. What is affecting refugees or asylum seekers will be the proposals that have been made by Priti Patel, the Secretary of State, which seem to the government is saying that will streamline the process, but it's actually tightening the process. They say that they are targeting people who do trafficking of people from outside the United Kingdom, the professional traffickers. So basically, if under the new proposals you are given refugee status, you'll be given settlement straight away without the 5 years. If they don't give you, then it makes it much easier for them to remove you from the United Kingdom. They are also considering maybe housing people outside of the United Kingdom, more like what maybe Australia have done, that asylum seekers housed in an island somewhere else. But Brexit is not per se affecting the refugee status. So if you have a refugee status, you will continue with your refugee status. Your 5 years, and then you go on your settlement, and after the settlement you can apply for indefinite leave to remain. If you were in breach of immigration rules, for example, within the last 10 years, then you will not qualify for the naturalization until 10 years of legal stay if accrued. So that's about the refugee status. I always get questions from people: should I go back when I get my settlement, whether on discretionary leave to remain or on refugee status settlement? My advice is that normally it's best to wait until you become a British citizen, but it's up to you really. Some people are lucky, some people are not, but I suggest that you go after you become a British national. We can assist companies to get a sponsor license outside of the healthcare field. We do have companies that we are helping as well that are outside of the healthcare field that have got specialties in other fields. We have got some clients who are in the IT field, the insurance business. Those want specialist people, for example. We are helping them as well. So yes, we can do that. And we can apply for the sponsor license for the companies. But if you get a job from a company that has got a sponsor license in whatever field that you have, and you want us to help you with a visa application, we can, as long as your employer has given you the sponsor certificate and you meet the requirements. By and large, the requirements will be that you need to pass an English test, the IELTS. You need to have some maintenance money, unless if you're getting a relocation package from your employer. Depending from the country that you are coming from, you need to be tested for TB, and you meet the qualifications of the job that you're coming to do, which obviously under recruitment, the employer you have checked. You can also come with your family, your husband, wife, partner, and children. You need also to have the maintenance money. I think I've mentioned that. And you can extend it. You can get a 3-year visa or a 5-year visa. After that, you get your indefinite leave to remain, and ultimately your settlement, as long as the employer can demonstrate that there is a job and you are still required for that particular job. So yes, it is quite possible to get to enter the United Kingdom through that route. What about people who are outside UK? Can they apply jobs using employment license to come here? If you want to come here, the first thing that I would say is go on the skilled worker shortage list. or some jobs that are applied for specialist people and see if you can qualify. Then you follow the recruitment process. You make a job application to the employer. They check your CV and everything of it. If they've offered you a job, then you can then come as an employee of that particular company. I have heard inquiries from people who have had Zoom interviews or Skype interviews with companies that don't have a sponsor license, and they've said you can come to the United Kingdom, sponsor yourself. It doesn't work that way. People are misinterpreting the word sponsor. The word sponsor is not necessary under the circumstances. Is not necessarily about money or finance that someone who paid the ticket for you, or it is about someone who has been given the authority by the Home Office to recruit someone from outside the United Kingdom, and that person will then give you a sponsor certificate. So there's no point for you to do all those interviews with the company that doesn't have a sponsor license, a sponsor license, and then expect to come to work for them. That's not gonna help anything. So don't waste your time doing that. The fees of the 20-year route is £1,033 for each applicant. The insurance health surcharge is £1,560, and the biometric enrollment is £19.20. If you are struggling to pay those fees, then you can apply for a fee waiver. And if the Home Office is satisfied that you cannot pay for the fee and you are destitute, or paying the fees is likely to render you destitute, then they can give you a fee waiver. They generate a code which can then be imputed on the application form when someone is making the application. So those are the fees of a 20-year route. And in addition to that, there is also the fee of the lawyer or the legal practitioner at Chan Law. We do charge some fees which appear on our website, and sometimes if the lawyer is applied for exceptional funding, you might be able to make the application with exceptional funding. But by and large, those are the kind of charges that you will be facing. How do you find companies that have sponsor license? Oh, that's a big one. Let me see if I can. There's a sponsor register, and it's quite a massive. It's thousands and thousands of pages, and you will really need to have the time to go through it. Or if there's a recruitment agent, we are not a recruitment agent ourselves. I think maybe I've seen some companies that are marketing that they can recruit people. So maybe if you approach them, they can have they've been instructed by maybe certain other companies to recruit on their behalf, or they're recruiting themselves. I've just put in the link of the sponsor register for anyone who's interested. You can go through it, but it's quite massive. How much do we charge for applying a visa? Our fees vary depending on the visa application or the process that we are doing. If it's a Home Office application, let me just get it off the website, and I'll put it again on the chat. But if it's the Home Office application, on average, our fee is from $950 to $1,100. If it's an appeal, we do charge a different fee. If it's a judicial review, we have got a different fee as well, which we charge. So it just depends with whatever instruction that you are giving us, that will then determine the fees that we charge you. So I'm just getting the immigration. That is a guideline of the fees that we charge, and each case is different. It's just a guideline. It will not be on all four squares on each other. Someone is asking about a visa to come to the United Kingdom as a domestic help or as a nanny. Most of the time, it will be maybe for diplomats or for people if that person is a domestic help and within the last 12 months with whom they were staying with. It's quite a few people will be able to successfully apply under that route, but it's quite possible. The domestic help visa or a nanny visa is some people call it. Diplomats can do that, and also maybe if you have been with that family for the last 12 months and they are relocating, you could be able to relocate with them. Okay, so I'm just checking through some of the. So I'm checking through the questions that I had. Those are the questions which are in the chat. From what I can see from where I'm streaming from, I might have missed some questions, but if you have any questions that you want me to respond to, you can contact me on the details shown there, and I can gladly and happily respond to you. Thank you so much for having me today, and I will be with you again next week when we discuss other topics as well. Thank you.